Chair.
Okay. Carmel Sepuloni, final call.
Thank you, Mr Chair. Mr Chair, I just want to refer to something that my colleague Chris Farfoy was talking about earlier, and that was in relation to clause 48B, so application for change of name by registrable offender. So in this clause it states that the offender must not apply to the Registrar General to register a change of his or her name under the Births, Deaths, Marriages and Relationships Registration Act without first having obtained the written approval of the Commissioner. It then goes on to say that an offender who, without reasonable excuse, contravenes that subsection, commits an offence and is liable on conviction to imprisonment for a term not exceeding 2 years or a fine. What I want to check with the Minister is why the Department of Internal Affairs, particularly looking here at births, deaths and marriages, hasn't been included as one of the government agencies where information would be shared. I'm just thinking that if the offender does attempt to register a name change, that actually there's no checks and balances in place. There's nothing there that will actually capture the fact that this is a convicted child, a sex offender, and so therefore they could successfully change their name. So I want to know from the Minister whether or not she would look at extending the sharing of data amongst agencies, because if we look at page 2 where the commentary is, it states really clearly that the specified agencies at this stage are just the police, the Department of Corrections, the Ministry of Social Development and Housing New Zealand. So I want to ask the Minister whether or not there would be any consideration for including the Department of Internal Affairs to avoid the possibility of a registered child sex offender being able to change their name. I would like to hear from the Minister if that's possible.
David Clendon.
I'd just like to speak to one specific point, which is